Although Canada has one of the best justice systems in the world, there is nevertheless still a need to keep pace with change and to adapt those laws. Our day-to-day lives have changed a great deal since Canada's criminal code was first enacted, 1892. Much like other democracies around the world, Canadian society and its values have and are continuously evolving, and our justice system needs to evolve as well. Our governments want to prevent further victimization and make sure that Canada's most serious, violent criminals are kept off the streets. Under the previous administration, year after year, and this continues, we've heard stories of violent criminals who reoffended immediately upon release or released earlier than the public might think appropriate, and this is an ongoing issue and one that shakes people, particularly if it affects somebody you know or your member of your family. Not surprisingly, many Canadians have found this offensive, and has it led to that serious lack of confidence. It's easy, if crime doesn't touch you, to say, well, I'm sure it's all okay, it's working out there. But this is where community and a sense of understanding the effects on our neighbors and our friends matters. And just after we introduced this crime bill, I got a call from a constituent whose sister had just been murdered up in the Okanagan by her husband in their home by gunshot. And her family was in terrible turmoil. And I can't comment on a specific case that is before the courts and the system, but I'm just saying, when you get a call like that, and you hear how that is affecting that family, and when you sit on the Justice Committee, as I have, and we heard from 50 witnesses in the fall, many of whom were either victims themselves or speaking for a victims advocacy group. These are just heartbreaking stories. And yes, much of law enforcement is reactive, but we can do our best to both prevent crime and after crime happens to deal appropriately if we're dealing particularly with serious offenses, violent offenses, or those who are chronic reoffenders. When Peter and I were at the session in Richmond, some of the business owners there were talking about the effect on their businesses of crime, of the boldness of people coming into malls and holding up their employees at gunpoint. It's one thing for a young kid to run and snatch a phone or something out of a kiosk. It's quite another to have employees locked in the back of a business and gun and violence involved. These are serious issues. They impact us just as community members, but also business owners and those who want to do business in our communities. So we are aiming at those most serious violent offenders. A more recent example is our action on mega trials. As I'm sure you're aware, it has become increasingly difficult to ensure that such trials take place and are completed within a reasonable time. Many of you would have read of the Quebec circumstance where there were 34 people, offenders, accused, I should say, believed to be part of organized crime, a bike gang, and all 34 were released because the system felt that their matters weren't being dealt with in a timely enough fashion. That actually helped gain us all-party support for this mega trials bill. So the NDP opposition, the Liberals who are currently the third party, and the Bloc Québécois supported this. The only holdout was Elizabeth May from the Green Party, but more or less I call that all-party support because we had to do something to deal with these mega trials. The problem is they often feature complex evidence, you have multiple accused and numerous charges, and witnesses that consume a great deal of court time. They also cause excessive delays and can increase the length of pretrial detention. Worse, they increase the risk of mistrials. So mega trials, we can't avoid them, particularly if we're talking about organized crime or terrorism prosecution, but the manner in which they are conducted could be improved. So we brought in the Fair and Efficient Criminal Trials Act. It was introduced in June. It came into force shortly thereafter. What it does is it strengthens case management. So it empowers case management judges to rule on preliminary issues and decide on admissibility of evidence, reduces duplication of processes through permitting joint hearings, is up until now, even if you had multiple accused and it was all arising out of the same facts, you had to start from the beginning of each and every one and move them through their own process. This allows some of that to be done jointly, and those decisions stand through the trial process. It also improves criminal procedure by increasing the maximum number of jurors from 12 to 14 and instituting measures to better protect the identity of jurors. When I first heard that, I thought that sounds so strange. We're so used to a 12-juror system. But in Canada, we have to have a minimum of 10 jurors. Sometimes, if it's a long trial particularly, people fall away because of business commitments, health issues. So now 14 can be chosen, they hear the evidence, and then it's randomly chosen the 12 who will deliberate. And that makes it, unlikely that you'll go below the minimum of 10. Because there can be no true justice if people, especially our most vulnerable, fear for their safety and security, we need to move toward a safer Canada, a justice system in which Canadians can continue to have confidence. That is why we introduced the Safe Streets and Community Act, Bill C-10. That's the one you have the rundown on in those handouts. It is now before the Senate and addresses a wide range of significant law and order issues that affect our society. Among other things, this bill will help protect children from sexual predators by increasing penalties for sexual offenses against children, as well as creating 2 new offenses that take aim at conduct that would facilitate the sexual abuse of a child. I want to mention there that we hear a lot in the news about, well, crime is down and overall statistics in Canada, why are you even looking at this? Well, the fact of the matter is that it is not down in all geographic areas, and it's not down in all areas of crime. One of those areas, for instance, child pornography offenses are up 36%, drug trafficking offenses are up over 11%. And this bill in particular targets those 2 areas. It also targets organized drug crime when aggravating factors are present by creating tougher sentences for the production and trafficking of illicit drugs. Again, you hear information out there, they say, oh, we're after a college student who has a couple of plants in their kitchen. That's the example I've heard, and it's simply not true. What we're doing is saying where there is drug trafficking and there are aggravating factors, which is the person is proven to have been part of organized crime, or the person is proven to have committed that crime with either violence or threat of violence, or where our children are being targeted, then these minimum sentences come into play. And we, yes, are trying to send a very clear message that this is not to be tolerated in Canada. Conviction for any sexual offenses against children will now carry mandatory minimums. We are trying to send a very strong message that we do not agree with our children being victimized in this way. It's an issue we take very seriously. With respect to drug trafficking and production, those aggravating factors I mentioned that attract mandatory minimums are where this is in the sentencing phase. This is where the person is proven to have been part of these kinds of crimes. There is an exemption, and I think it's an important one, for those whose crimes are non-violent but related to drug addiction. If a person is willing to go through a court-approved treatment program, his or her sentence may be reduced or suspended. Last week, in fact, I was with the BC Attorney General, Shirley Bond, to announce and support the 10th anniversary of the Drug Treatment Court in Vancouver's downtown east side. It's jointly funded by our 2 levels of government. Interestingly, there's 6 across the country. In other provinces, they're funded by the federal government and non-profits. But here in BC, it's funded by the province and the federal government. An independent SFU evaluation has just published, that has just been published, it actually went online last week, which found the recidivism rate reduced by 50% for graduates from that program. Bill C-10 will also ensure our justice system responds to the problems posed by youth crime by using fair and appropriate measures to hold young offenders accountable when they break the law. Again, no youth will ever serve time in an adult facility, but it does allow for youth, and they're usually on the high age end of that bracket, who are involved in serious, repeat, violent offenses, to be given, in some cases at the discretion of the judge, a longer sentence so that they can have more time with our programs, which try to get them into a different life. The victims of crime and their families also deserve to know that we are taking action to keep dangerous and repeat offenders off our streets. Two pieces of legislation that came into force this past December attest to that commitment. Bill S6 eliminates the faint hope clause, ensuring that criminals who commit first-degree murder will no longer be eligible for early parole until they serve the full 25 years of their sentence. The most classic example of that is, unfortunately, a homegrown example of Clifford Olson, who would ask for those parole hearings every 2 years. The families of all those murdered children would have to revisit it, go through the pain again. Sometimes he would cancel them the day before. Sometimes he would do it with taunting letters, I might add, to the families and others, MPs, senators, taking very much advantage of that system. So we have put an end to that. And Bill C-48 ensures truth in sentencing so that those who commit more than one murder will face the possibility of serving parole ineligibility periods consecutively. This means the length of their sentence will better reflect the severity of their crimes. We heard a lot from victims, and unfortunately these situations do exist in Canada and around the world, where there's been multiple murders, and they don't feel the murder of their loved one, the life of their loved one, is really taken into account when you collapse into concurrent sentences or concurrent parole eligibility. So this allows a judge in their discretion to say, in appropriate circumstances, if someone is a multiple murderer, they may be ineligible for parole consecutively. In other words, 25 years upon 25 years. Which means in the case of someone who is a serial killer, perhaps someone like that, they're not going to be released.